We thank you so much for watching Voices of the Bar, where the legal world speaks, but statistics show that only 40% are watching and they are subscribed. The 60% are watching and not subscribed. So we ask you to kindly subscribe. Don't watch minus subscribing. Kindly just hit the subscription button. Again, uh, the video you actually don't see on Voices of the Bar, you could possibly check it out on Law School Made Easy. We have two channels, so some videos are on Law School Made Easy, and other videos are on uh, Voices of the Bar. So we ask you to kindly subscribe to both channels, but subscribe to Voices of the Bar, where the legal world speaks. And then today we are here for family law. And like I earlier promised, that we are going to discuss what we mean by caveat in marriage, caveat on the issuance of the certificate of marriage. Remember, we said under section 11 of the, also section 6 of the Marriage Act, that one must issue a notice, and we also agree that that notice must be put on the outer door of the registrar's office for purposes of scrutiny. We want to find out whether there are people who are against this type of marriage, who are against these people. If somebody is claiming that the person who you intend to issue a certificate with is already married under customary law, is already married under this type of marriage, and the person they are brought before you is not the same person they married in the customary law. So the caveat is what we are going to discuss in this video, and particularly I shall discuss how to put a caveat on the issuance of certificate of marriage, and then how to uh, what happens when a caveat is actually put on, and what happens after the High Court has declared that a caveat should be stopped, or removal of caveat. So then to discuss the removal of caveat. All these are under section 13, 14, and 15 is a joint trade. If you want to appreciate about caveats, kindly read section 13, section 14, section 15, and section 16. This is a joint read. So let's straight enter now into caveating a issuance of certificate of marriage. Now, when we talk about caveat, we are going to come across this same concept under land law. I think that should be over around section 100 in the RTO. We shall come across we shall come across the caveat that is put on none, and we shall discuss the types of caveat, beneficial caveat, and very many other types of caveats. But now this is the caveat in marriage, that if somebody has an issue, let me first give you an example of church marriage. When you go to church marriage, there's that moment where the minister in charge of marriage at the church says, when you're taking vows, where they say that if somebody is there and you have anything that could possibly stop these two from getting married, please, it's your time, shine. It's your time. Say it now. Now, that moment is what now we are discussing here. That the reason why the church does the banns, if you check my video about church marriage, there are the bands which are played in church, the announcements. Now, that time of announcement, a caveat can be put on a marriage, that when you announce, Mr. Walter and so, I intend to get married on this date. Now, if there's somebody who knows that Mr. Walter is married to another person, then they can now begin the process of issuing a caveat on, or putting a caveat on that marriage. So even if it was in civil marriage, where we said that the registrar will put a notice at the outer door for purposes of getting complaints and scrutiny. So when a caveat, when somebody lodges a caveat and somebody says no, the intended couple should not actually get married. And then they give their reasons to the registrar. Now, when the registrar is satisfied, then a caveat shall be put into on that marriage. That marriage shall be stopped. All the processes in that marriage shall be stopped. Now, when the process is actually now stopped, it is not stopped by way of mouth, that the registrar will say, now we have gotten somebody who is complaining. No, 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 no. The registrar shall be forced to write in the marriage notice book the word forbidden. That these two particularly, they will put a word forbidden, and then they will sign and also put the name of that person who is complaining about that particular marriage. When the word forbidden has been entered into, then that literally means that you cannot continue with your preparations of marriages, because the registrar has not cleared you with the certificate. So the registrar will withhold giving you a certificate of marriage for you to continue with your preparations, your preparations. So when the word forbidden is entered, then that means that the registrar, under section should be 14, is going to send the matter to the High Court. It is the High Court judge who will listen to this matter where a caveat has been lodged on stopping the issuance of a certificate to the intended parties to get married. All matters pertaining caveats are now forwarded to the High Court. There is no shortcut, colleagues. They are now forwarded to the High Court. Now, the moment they are forwarded to the High Court, then the High Court will determine. Of course, the person who alleges must prove. So we enter all that evidence, and then court will declare itself on that caveat, either to remove the caveat. If court is served with sufficient evidence, then they'll either remove the caveat or retain it and say these people are not supposed to get married. Now, the moment court declares that a caveat can be removed, then the registrar, under section 15, then the registrar of the Marriage Act, then the registrar will have to go to the marriage notice book and cross out the word forbidden and put there cancelled. The word cancelled. The moment the word is said cancelled, then you have been given a green light that continue with your preparations for the marriage, and therefore the registrar will at that particular time issue you with a certificate, which now means that you continue with your preparations. So that is how a caveat is launched, and that is how a caveat can be removed. And we have also discussed, if a caveat has been put, where do we go? Automatically your matter is referred to the High Court. So we want to thank you so much for watching Voices of the Bar, where the legal world speaks. Subscribe, share, and keep liking our videos. Until next time, thank you so much. See you. Cheers.